It gives me great pleasure tonight to introduce a dear friend of mine, as well as the museum. This would be Judge Chumley's third appearance with us. He has spoken in the past about the Declaration of Independence. Last year he spoke to us about the Constitution, and this year the Bill of Rights. In fact, today is the exact date that it was ratified by Congress in 1791. So, an evening with Judge Chumley.
Thank you so much. I appreciate that, Tom. Thank you for your kind words, and thank y'all for coming out tonight on a cold Friday night. I'm glad you're here, and I always enjoy speaking on the Bill of Rights. In fact, my daytime job is a criminal court judge, but I do frequently teach college classes at night in government and business law, and so I always go over the Bill of Rights and the Constitution and make sure everybody understands it. So I'd like to get into it a little bit and talk a little bit about each one, the Bill of Rights, and kind of bring out a few little interesting things about them. But you know, first of all, you have to understand the history behind the Constitution before you can really understand the Bill of Rights. And what I've done tonight is I've got a copy of the Constitution that I want to pass out so we can all follow along and take a look at it while we're talking about it. And if you don't have a copy of the Constitution, you're welcome to keep this if you like. If you do have a copy, then I'll take it back up if you don't need it, because I sometimes use them when I speak. But we'll go ahead and pass them out and let everybody have it. And I think we probably got enough for everybody here. But if we don't, maybe we can double it up and take a look at them. And look at all these couples. I didn't know exactly how many to bring. Okay. I would have some more, but I always end up get fewer every time I speak. Yeah, does anybody else need one? Well, we've got a couple if we need them, but we can take them and refer to them. The Bill of Rights is something that has a really unique history to it as far as the Constitution is concerned. You have to really understand the revolutionary history, the revolutionary background to forming the Constitution. And the interesting thing about it was, when the Constitutional Convention was taking place and all the delegates were hashing out all the details of the Constitution, of course you know the Bill of Rights were not a part of it. And of course there had to be 9 states to ratify the Constitution before it would actually become a binding document. Now the interesting thing about this is, if you look back at the Articles of Confederation, the Articles of Confederation was a government that held together the Union, so to speak, before the Constitution. The second article of the Articles of Confederation made it explicit that each state kept its freedom, its sovereignty, and its independence. So each state was to be bound by its own voluntary act. Those are Madison's words in the Federalist Papers. So it was up to each individual state whether they wanted to adopt the Constitution or not. After the Constitutional Convention hammered out the details and kind of agreed on it and agreed to sign it, of course there were some, couple of notable individuals, George Mason among them, who refused to sign it. Still, it was up to the states whether they adopted it. Now, 9 states had to ratify it. If only 8 states ratified the Constitution, they were going to scrap the idea and go back to the drawing board. So they didn't know what was going to happen, and it was a real fight in a lot of the states because a lot of the anti-federalists really opposed it. A lot of the states' rights people, the people who understood that the states were sovereign, had a real problem with the Constitution. As a matter of fact, in the South Carolina ratifying convention, General Thomas Sumter, the hero of the Battle of Blackstocks, and the partisan leader from South Carolina, he voted against it. So General Sumter goes down in history. He voted against the Constitution because he had the same fear that so many other people had. He was afraid it was going to take too much power away from the states. This is a major concern. And now looking back 200 years later, those people, those anti-federalists, you see that probably a lot of their fears were well-founded because of the fears they had, especially of the judicial branch, which I feel like is the one. Hamilton called it the least dangerous branch. Hamilton was a brilliant man, but that was a glaring error on his part there because judicial branch has become certainly not the least dangerous branch. It's become probably the most dangerous branch to American liberty and American freedom. So all this is going on, and all these things. The Revolution had been fought. The Treaty of Paris was signed in 1783. So we had, years of peace, 4 years of peace before they got to the time of the Constitutional Convention. And everybody saw that there were some problems trying to work together as a union. So it was a pretty general agreement to get together and do something and make some changes. Of course, all that anybody agreed to was to make some revisions to the Articles. But in any event, they went there and they sort of wrote down this document. And really, the Constitution is just a revision of the Articles. That's what it was intended to be by the founders. So let's take a look at it. Okay, you got 9 states that finally ratified it. Okay, South Carolina being the 8th one. So we came in there as number 8 and finally did ratify it. So you had 9 states. Well, that meant it went into operation. But keep in mind, it only went into operation among the 9 who ratified it. The 9 did not bind all 13. The other 4 states that had not ratified it were not a part of the Union. They were out of the Union. And North Carolina and Rhode Island were 2 of them. And Rhode Island held out for the longest. And all during that period of time, Rhode Island was treated as a foreign country. It was not part of the Union because it had not agreed to ratify the Constitution. Now, they ultimately did. But that's what happened. Only those 9 that ratified it did it go into binding effect. Now, out of the 9, 7 of them had a condition to their ratification. And when they hammered it out at the state level and finally agreed to ratify the Constitution, 7 of the 9 said, look, we'll ratify it cautiously and reluctantly. Because keep in mind the history of these people. Okay, our forefathers, our ancestors, they had just fought this tremendous revolution against the greatest military power on earth. They had just defeated England. They knew what overwhelming government power did to people and how it took away their freedom and their liberty. The last thing they wanted to do was exchange one tyrant for another. So 7 of the 9 states that ratified it had a condition, and their condition was this. They said, we'll only do it if you include a Bill of Rights, which lays down some basic English freedoms that we've all become accustomed to. Well, this was not talked about at the Constitutional Convention. This is not referred to in the Federalist Papers. You can't get a lot of background information on the Bill of Rights like you can the Constitution. You can go to the Federalist Papers, you can go to the Constitutional Convention debates, and you can explore and find out a lot about the Constitution. No such information on the Bill of Rights because this came along later. Because these states demanded it. They said, we're ratified only if you give us this Bill of Rights. Now Madison, as you all know, was opposed to the Bill of Rights. Everybody know that? He didn't like them. He didn't want them to be there. There's a very simple and obvious reason why. Madison said, look, or let's put it in today's terms. It's just like if we go to Walmart or we have to go to the grocery store or something. Okay, Tammy and I have, and I can introduce my wife, Tammy, and my 2 girls. This is Georgia and Charlotte. By the way, my wife homeschools them, so this is part of their school tonight too. Okay? So they get a little of their civics lesson in. I also have 2 boys. My oldest boy is Sumter, and my second son is Hampton, and then we got Georgia and Charlotte. So you can see we stick with history. Yeah, and this is Charlotte Marion, she's named after the swamp fox, but Tammy's great-great-grandfather was also named Marion, so it's also a family name. But the interesting thing about it is when we take 4 kids and we go somewhere like Walmart or the grocery store, if you make out a grocery list, inevitably what always happens, you get home and you find there's something you forgot, right? It happens all the time. Well, this was Madison's fear. He said, if you start listing your rights, you're going to leave something off. Just by omission, just because you're not thinking about it. And his fear was, because these men were such geniuses, it was such a, anybody that says that this country is not blessed by God, it was not God ordained, they don't know their history. Because the Lord put this country together, because He put together such brilliant men at such an important period of time, that these people actually come up with something that I don't think it could ever be replicated. Which, by the way, this is an aside, but that's why I don't support this Article 5 thing that a lot of people are trying to suggest, because we'll never have people like we had before to put together a Constitution. And we're asking for destruction if we start messing around with this document. So I think that we need to leave it alone and just enforce it the way that it was written. But Madison's concern was you're going to leave something off your list. And if you leave something off your list, being the man that he was and having the brilliance that he had, he knew 150, 200 years down the road, some judge would say, well, I can't find it in here. You must not have that right. Okay? So he said you don't need to list it because the Constitution doesn't take away rights. It simply binds down the federal government with chains to keep it from taking away our liberty. So why do we need to list the rights we have? Because if the government can't take it, you have that right. It's God ordained. God gave it to you. Government doesn't give rights. Government is chained down and restricted from taking your rights. And so that was why Madison opposed the Bill of Rights. You start listing this stuff, you're going to forget something, and somebody's going to come in there and they're going to say, well, it's not here, you must not have it. But Madison did introduce it so that it could be ratified on December the 15th because he realized 7 of the 9 states were not going to ratify unless they got the Bill of Rights. This illustrates how fearful they were of centralized power, how fearful they were of a federal government, of a national government. And again, that just shows how intelligent and brilliant and forward-looking they actually were. So, they did it. They went ahead and added the first Bill of Rights, the first 10 amendments to the Constitution, because to answer the concern of these states. Now, Massachusetts and Virginia were 2 of the states that demanded the Bill of Rights. Okay, those were 2 that did it. And even after the agreement was made and the promises were kept and the Bill of Rights were introduced, 3 states still specifically reserved their right to secede if they wanted to. Does anybody remember off the top of your head, any of our historians here, who the 3 states were that specifically reserved their right of secession? New York, Virginia, and Rhode Island. Yeah. So, now that doesn't mean that the others were against secession. They just didn't think they needed to mention it. New York, Virginia, and Rhode Island simply said, we're going to reserve the right to leave. We want that Bill of Rights. Once we get it, we want to remind you, we can leave if we want to, because we're voluntarily joining, we can voluntarily leave. And that was part of my talk on the Constitution, where it was the fact that it was the consent of the states that put this together. But let's go ahead and take a look at it. If you got your Constitution there, flip over to Amendment 1, which is the beginning of the Bill of Rights. And we'll go ahead and take a look at it and bring out some stuff here. First of all, let's go ahead and take a look at it and just read the first one. Okay. First Amendment. Congress shall make no law respecting an establishment of religion, or prohibiting the free exercise thereof, or abridging the freedom of speech, or the press, or the right of the people peaceably to assemble, and to petition the government for a redress of grievances. They crammed a lot in here. But the first thing you notice is the Constitution restrains the federal government. It's not a restraint on state governments. Contrary to what a lot of federal courts tell you today, they'll say, you know, you've got this incorporation doctrine of the 14th Amendment, which come along after the war between the states. There's a lot of legal history. You just have to go in to get into all that. But the founders that would have been foreign to them. Their understanding here is this document restrains the federal government. That's why they say Congress shall make no. Congress shall make no law respecting an establishment of religion. Okay, well, we know that. Use your freedom of religion here. And there's 2 clauses which you constantly hear federal courts debate all the time. You've got the Establishment Clause, the Free Exercise Clause. Okay, Congress shall make no law respecting an establishment of religion. Okay, that's what, you can't have state religion. This, again, did not outlaw individual states having their own state religion. And they did. The official church of the state of South Carolina was, y'all remember that one? The Anglican Church was the official state church of South Carolina. And who was the last state to have an official state church? Does anybody know? Massachusetts. Massachusetts is the last state to have an official state church, and that was 1833. So over a generation after the ratification of the Constitution. So what this does is it restrains the federal government from having a national church like England had. That was the only purpose of the Establishment Clause. Now, the free exercise clause follows it up, and it's a freedom, and it says that you can do whatever you want and worship anywhere you want. All that's in the First Amendment. Now, then we go into there and we talk a little bit about freedom of speech. Freedom of speech is very interesting. There's a couple things. If you got anything to jot down these three words: time, place, and manner. Those are the ways that you restrict speech, and that's what courts have determined is appropriate restrictions on speech. When you say it, where you say it, and how you say it. But content neutral. Your opinion can't be restricted. That's wrong. That's what the Constitution says. You can express any opinion you want about anything, no matter how ridiculous it might be. Okay? You can run around and say that you think that, all Americans ought to spray paint each other blue. Okay? The most ridiculous idea you think of. But that's an idea you can express if you want to. Okay? It's a freedom. No content. You can write about it. You can speak on it. You can do whatever you want. Your political views cannot be restricted, no matter how ridiculous they may be, how wrong they may be, whatever. Okay? You can say whatever you want. What can be restricted and what courts have found is reasonable is, again, time, place, and manner. It depends on where you say it, what you say, how you say it. Okay, where it's said, and the manner in which it's said. So, in other words, the classic example is you can't go in a crowded theater and yell fire, because it's a danger issue, it's a safety issue. So, those should be the basis of restrictions on free speech. So, as a free American, think about that whenever you hear a government regulation on speech. Think about it and think, does this restrict content and opinion? If so, it's probably unconstitutional. If it just says that, hey, you can't incite a riot, that's probably understandable because there's safety issues involved. That's the restrictions we're talking about. But freedom of speech means you have freedom to express your opinion. It should be content neutral. All right, let's see, what else did we miss here in Article 1? Freedom of the press, okay, that, Thomas Jefferson was big on that one. He figured, you need to be able to, these nosy reporters should be able to get in and find out whatever they want. That way, we, the people, find out what's going on in our government. And that's a good thing because, it's out there for the people to know. People need to be informed. In fact, this is a great quote here from the Bible, Hosea 4:6. It says, "My people are destroyed for lack of knowledge." So in that understanding, they felt like the more light that could be shown on government regulations or whatever's going on, or government policies, the people know more about it. So that's the freedom of the press. An obvious thing to us, but at the time, something they were concerned about. Then, the right of the people to get together, to gather together, to assemble, and to petition the government, to tell the government they're doing something wrong. All that is crammed into Article 1. Now let's take a look at Article 2. Article 2, your big one that comes up all the time, your big controversial amendment you hear people talk about. A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. Now we've heard debates about this. We had a guy come speak to us when I was in law school. I was in the Federalist Society in law school. And we had a speaker one day come in there. And this guy was supposedly a legal scholar. And he tried to tell us, law students, he said, what this means is that military officers or the police can keep guns, not individuals. Now, we know that's ridiculous. It doesn't take a lot of research to figure that out, especially if you know the history behind the Constitution. Okay? It was really the attempt to confiscate people's weapons that started some of the first shocks of the Revolution. So anybody with any understanding of history understands that. But that is still a position that you constantly have to contend with. Needless to say, his visit didn't go very well at the Federalist Society that day when I was in law school. Even though we were all a bunch of law students, we kind of let him have it. So that was encouraging. But the point is, it's for the people to keep and bear arms. And so I've got some quotes I want to give you about that. One thing you can jot down if you want to remember this is Federalist number 46. Madison points out in Federalist 46, it's the people we're talking about. Us. We're the ones that can't have our guns taken from us. Our rights can't be infringed. But here's some interesting quotes here. Listen to this. This is from an article that Walter Williams, y'all know Walter Williams, a syndicated columnist? He had an article here, and this particular article is from the year 2000, and he's quoted several people just on Amendment 2. He quotes Thomas Jefferson. He says, "No man shall ever be debarred the use of arms. The strongest reason for the people to retain the right to keep and bear arms is, as a last resort, to protect themselves against tyranny and government." Okay, that's pretty basic, okay, Thomas Jefferson. Or how about this? Tench Cox, Assistant Secretary of the Treasury in 1789. He said, "The unlimited power of the sword is not in the hands of the federal or state governments, but where I trust in God, it will ever remain in the hands of the people." That was the Assistant Secretary of the Treasury. And this is one of my favorites. Noah Webster, the guy who wrote the dictionary. And I've got one of his original 1828 dictionaries at home. Not an original one, but a facsimile, a copy. And I use it all the time as my dictionary because it was one of the first ones that he wrote. Here's what Noah Webster said. "The supreme power in America cannot enforce unjust laws by the sword because the people are armed and constitute a force superior to any man of regular troops." Noah Webster. And then, of course, he goes on and he quotes James Madison in Federalist 46, where he says, "The Constitution preserves the advantage of being armed, which Americans possess over the people of almost every other nation." And, of course, we know that's what tyrants do. The first thing they do is disarm the people. So that's the purpose of the Second Amendment. Great. Their experience, they put it in there. Excellent stuff. Now, the Third Amendment. The Third Amendment's very interesting because it made specific reference to the quartering of troops. Now, I know y'all have read all this stuff over here in the museum. It's great the way y'all got this set up. But you know the widow of Richard Richardson. Remember the story over there about the widow of Richard Richardson? Okay, she had warned Francis Marion that Tarleton was in the area. And then when Tarleton came to their plantation, what did he do? Forced her to feed him. And then, of course, he dug up General Richardson, who had just recently died. So this is what the British did. They would come in and demand people feed them and quarter their troops. So this is something the founders were experienced with. So they put this in here to realize that the people do not have to quarter troops. So Article 3 says, "No soldier shall in time of peace be quartered in any house without the consent of the owner, nor in time of war, but in a manner to be prescribed by law." Now, let's take a look at Article 4. Article 4 is really good. "The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized." This refers to search warrants. Now, as a judge, that's what I do, is I deal with search warrants pretty much every day. Search warrants, arrest warrants, when we're not in court. What the Constitution requires is that a police officer, before they come on your property or search your house, they've got to have probable cause that a crime has taken place. And they can't make that determination on their own. They gather the evidence, they go to a judge, and then we make that determination, or a judge makes that determination. If we find there's probable cause, then we issue the search warrant. So what that does is the police can't make that determination, but it's to be a judge that does it. Now, search warrants have to be very specific, and I have had to do this many times. Most officers are very good about putting together search warrants, but sometimes you have to remind them to make it more specific. But look at what it says here, okay? Particularly describing the place to be searched and the persons or things to be seized. They have to say what they're looking for and where they're looking for it. Because it wouldn't do for it to be some general description and them go to the wrong house down here and kick the door down and start searching the wrong house. Okay? Somebody's in serious trouble if that happens. So it has to be very specific. So we require, on the search warrant face, it has to describe how you get there. And usually what we require is that they start at the Spartanburg County Courthouse and tell us you turn right on Daniel Morgan Avenue, you turn left on St. John Street, follow out this road, you turn left, you turn right, and the place to be searched is on your left. And the numbers are on it, 165 Chestnut Street or something like that. So it has to be a specific place in this country, and that is a constitutional requirement. And so oftentimes I'll explain that, and I'll tell officers it's got to be specific to get a search warrant. And it's got to describe exactly what you're looking for. What do you think's there? What evidence is there? And what's the probable cause that backs that up? What evidence makes that probable that it's there? Then, notice it has to be on oath or affirmation. Before they can get one, to raise their hand and I say, you swear all the information you're giving me is true and correct, so help you God. They have to swear by oath that the information they're giving us is there. It's all a requirement right here. That's where probable cause comes from. And that is it's a low standard, because you've got, on one hand, you don't want criminals running loose, but at the same time, you don't want innocent people being threatened or pestered or something by a police state. You can't have that. You have to have that balance in order to have freedom. So there has to be something that probably says there's evidence there. That's probable cause. And all that is right there. So, search warrants, all out of Article 4. And that means that you have, and if they violate any of that, then it's what's called the fruit of the poisonous tree. Any evidence obtained is not admissible in court because it's the result of an unreasonable search and seizure, because it has to be a reasonable thing. That's why it says there are no unreasonable searches and seizures. Okay, so it's unconstitutional. Evidence can't be used. And in court, frequently they have attorneys, and they'll come in with pretrial motions, and they'll ask that evidence be excluded because it was unconstitutional the way it was obtained, or it was illegal. And the evidence obtained illegally is not admissible. So that's the way it's supposed to work. That's the due process of law. So far, so good. Anybody got any thoughts or questions so far up through the first four?
Review that for you, so that you,
Sir, I'm sorry.
does somebody help you by reviewing that so they can say that it's not, that it's proper that evidence should be presented?
Well, if it's a case that whoever the judge is makes the determination. Yeah, and usually if it's an in-court thing, we get a pretrial motion, and the defense, for example, makes the motion because they think the evidence was illegally obtained. The state may argue that they think it was legally obtained, and they make their arguments. And then, of course, we, the judge, will make the determination and make the call either admissible or not based on, what the facts are of the situation. Yes, sir. Good question. Anything else so far? Okay. Then let's take a look at the Fifth Amendment. The Fifth Amendment you hear about all the time because, the girls are not old enough to remember this, and our young attendees are not old enough to remember this, but back in the Oliver North testimony back in the late days of the Reagan administration, y'all may remember when all that was televised and Oliver North was testifying in front of Congress. This specifically stuck out in my mind because it was like all summer long. It was on TV. And back then, we only had 3 channels. So if TV was on, Oliver North was on, Now people just turn it off to something else or put a DVD in, I guess. But back then, we had to watch it because it was the only thing on TV. And I thought it was kind of interesting back then. This was probably 88, 89, or maybe earlier than that. No, it wouldn't have been 88 or 89 because Reagan went out. President Bush was elected in 88, so this is probably mid-80s. But anyway, I remember he would sit there with his attorney, they asked a question, he'd lean over and, talk to his lawyer, and he'd lean forward. Senator, I'll take the Fifth.
1985.
85, there you go, yeah. Time gets away from you, don't it? That's before you turn around, good as go.
I've seen that long ago.
That's right, that's 32 years ago now. So he would lean over and he'd say, Senator, I'm respectfully going to take the Fifth. He's talking about the Fifth Amendment, which everybody's heard, because the Fifth Amendment specifically protects you against having to testify against yourself. You can't be compelled to testify against yourself. Now, the Fifth Amendment is a long amendment. Let's just read it real quick. No person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury, except in cases arising in the land or naval forces or in the militia, when in actual service in time of war or public danger. Nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb, nor shall be compelled in any criminal case to be a witness against himself. That's the Fifth. That's the essence of the Fifth right there. Nor be deprived of life, liberty, or property without due process of law. Nor shall private property be taken for public use without just compensation. So they crammed a lot, like I said, in each one of these amendments. One of the biggest things, of course, is you can't be compelled to testify against yourself. If you don't want to talk, you don't have to talk. And one of the first things I tell people when they come in my courtroom is I go over their constitutional rights as a whole courtroom before we start. Then when each defendant comes up in front of me, I ask them, do you understand those rights? Make sure they understand that. Because I tell them, you don't have to testify if you don't want to. The state has the burden of proving a case against you in a criminal case. The defendant doesn't have to do anything. The defendant can just sit there and look. They don't have to prove their innocence. The state has to prove guilt. So you can't be compelled to testify against yourself. And very frequently people exercise that right, choose not to testify, or you choose not to say anything. And they have the right to do that. So that's in the Fifth Amendment. Taking the Fifth. Now also you got your right against double jeopardy. Y'all saw that there. Okay, if you're tried and acquitted, in other words, if prejudice is attached, is what they call it. In that case, once a court case has got far enough and prejudice is attached, that means you've been tried to that point. And if it doesn't get to, and if you're acquitted, you can't be tried again for the same thing. Double jeopardy protects you against that. But it is somewhat of a narrow protection. It only applies in the same jurisdiction for the same crime. So let's say Tom and I decide to go on a tri-state crime spree. And we drive all over upstate South Carolina, robbing banks, knocking over liquor stores. We go into Georgia, we knock over liquor stores, rob banks down there, we kidnap a few people, we steal some cars. And then we drive back into South Carolina, okay? We just have a wild weekend, okay? And we get back to South Carolina and we're arrested. And then both of us are tried for robbery in South Carolina. And we're acquitted. Does double jeopardy protect us against being tried in Georgia for the same crime? No, because it's a different jurisdiction. So they may pick us up, extradite us to Georgia, and try us for bank robbery down there in Georgia. Well, let's say we're acquitted there. Well, we might still come back to South Carolina and be tried for kidnapping or assault and battery. So it's only the same crime in the same jurisdiction. So it's a narrow protection, but obviously the key is to protect somebody from being hounded by the government, okay, after they've been acquitted. So that's double jeopardy. Then we've got the due process of law clause, which is mentioned there. It said you can be deprived of your life, your liberty, and your property, but not without due process. So can the government take your life? Yeah, you can be executed. Can they take your liberty? Yeah, you can be locked up for life. Can they take your property? Yeah, but not without due process of law. It has to be done by a legal process. The governor can't just come to your house and say, I like this land, I want it, you're out of here. It doesn't work that way. It's got to be done by due process of law. Okay, so that's what the Fifth Amendment does and protects us. And it gets a little bit specific. It protects us by what's called the takings clause. Now, has anybody in here ever had the government come and maybe widen up the road in front of your house? Had that done? Anybody ever had like a power line or something like that go across the back of your property? That's where the takings clause comes into place. Your property can be taken. It's called eminent domain. But it has to be for the public good. It can't just be, again, because the state senate likes that area and wants it. Can't do that. It has to be for the public good and they have to pay you for it. So can the government take private property? Yeah, but it requires just compensation and it has to be for a public purpose. So take a look at it again, the takings clause. It says here, private property shall not be taken for public use without just compensation. So if you own it, it's yours. You own it. Property is the key to freedom. It's actually the foundation of freedom. The only way that it can be taken by the government is in the name of all the people for public use. And they have to pay for it, which is typically and traditionally been fair market value. But now, of course, if they're going to ride in the road in front of your house, that ends up becoming a situation where generally people dicker for it, just like selling a car or buying a car, So that's required of the Fifth Amendment. Now, the Sixth Amendment talks about criminal prosecutions. And the Sixth Amendment says that in all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation, to be confronted with the witnesses against him, to have compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense. A lot of stuff packed in there. But basically what that's saying is, you have the right to a jury trial if you want one. Jury trial is a basic part of freedom. That way you're tried by your peers. You're not just tried by a judge. And so what I do is, when somebody comes in front of me for a case, I always ask them again, do you understand your rights and do you understand the charge? Because the Constitution says people have a right to be informed of the charge against them. So, if they don't understand, then they have a right to ask, what's going on here? Why am I being charged for this? Okay, and they have a right to speak. They have a right to a jury trial. If they don't trust the judge, they certainly can ask for a trial by their peers if they want one. In a criminal prosecution, they have that right. And another thing that I have to go through and make sure everybody understands is they have the right to an attorney or a public defender. People don't have to go forward without a lawyer if they don't want to. They can if they want to. They can go forward pro se without a lawyer, or if they want one, they got a right to one. Now, Seventh Amendment. Seventh Amendment is a little more obscure because it generally refers to cases at common law. And what it says in the seventh article is that in a case in controversy in common law, you have the right to a jury trial. And that basically means in civil cases, you have the right to a jury trial too. And it says here that in anything that exceeds $20 in controversy, you have a right to a jury trial. Okay, does anybody know what $20 in 1787 would be worth today in our terms? It's roughly $500 is what $20 is worth today. So basically what they're saying there is anything, over because nowadays anything is over $20. At the time, they were basically talking about $500, is essentially what that was. Now, how about the Eighth Amendment? The Eighth Amendment is always an all-time favorite because it says here, excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. Now, at the time of the Revolution, and if you look back and look at Patrick Henry, of course, was a country lawyer and a strong Christian man. One of the things that shaped Patrick Henry's mind, as I understand it, is him riding into town one day and seeing a minister tied up and being scourged, beat with a cat of nine tails. And that was pretty common back then. In fact, this particular preacher was beat until his rib cage was exposed. And then they beat him until they killed him. And his crime, of course, was he would not get a license to preach. He didn't think the state had a right to require a license to preach. And of course that impressed Patrick Henry, and that's why he proclaimed liberty. But that was relatively common back then. Okay, there were all kinds of really torturous type punishments. One of the interesting things that I like to read about, of course, is the Salem witch trials. That was early criminal law. And of course, mostly what they did then is just hang people. But Giles Corey was one of the men he's the man that was executed for being a witch in Salem. And of course, he was pressed with heavy rocks, a few added at a time. It took days for him to die by being crushed. It's a painful, slow, agonizing death. And of course, they kept doing that, saying all you got to do is admit you're a witch. He refused to admit it, so they kept adding on heavier rocks. So that was all allowed back then. And so this is cruel and unusual punishment. And of course, one of my favorite movies that my wife loves for me to get out Braveheart and watch it. Right? Braveheart's a great movie. It's not exactly a romance, but it's a good movie. But it's got some really good stuff in it. But of course, you see, William Wallace was put on the rack. It was stretched. You can imagine how painful that would be. And so that was still, the way things had been done. And of course, us being in the Revolutionary Museum, what happened to traitors against the British Empire at the time of the Revolution, right? Drawn and quartered, hanged, innards pulled out and burned in front of them while they were still alive. Basic torture methods. So they didn't mess around. So these cruel and unusual punishments that really just inflicted pain, that kind of stuff was outlawed. No stocks, no racks. No Iron Maidens. You know what the Iron Maiden was? The slow, torturous death of the Inquisition. You know, where the spikes would just go through people and miss all the major organs, and they would die that way. So, a lot of pain. If you stood up for your rights back then, you better be willing to back it up. So we're the recipients and the beneficiaries of all these great things that protect us against being tortured, which is not unusual. Another thing, you got a picture over here of the Provost Dungeon, the customs house over here in the museum. Y'all everybody been through the Provost Dungeon, the customs house in Charleston? I like to go down there in the dungeon part of it and see that down there. But you know that I think is that being that old of a building, you know, they kept people down there, kept some prisoners down there, and so you know back then if you were tied up or you chained up, you didn't get a bathroom break, and if there were rats in there were just rats in there. So there was all kinds of ways to be tortured back then. So the Eighth Amendment is really we take it for granted, but that's what gives us these freedoms that we enjoy, so that we can speak up without fear of being tortured. Now the Ninth Amendment I always refer to as James Madison's amendment. If you take a look at that, it's the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. The purpose of the Ninth Amendment is simply to say, just because we've listed a bunch of rights here, this is not all of them. That's the whole purpose of the Ninth Amendment, and that addresses James Madison's concerns, so that some judge couldn't say down the road, well, it's not here. And then, of course, one of my favorites, the 10th Amendment. The 10th Amendment was probably the one that was put there to be the last one because they felt like it was one of the most important ones. That is to say simply, hey, the states keep the powers they don't give to the federal government. It should be a restatement of the obvious. And this is what the founders thought. This is a restatement of the obvious. If the states haven't given it, then they kept it. And that is consonant, according to Samuel Adams, with the second article of the Articles of Confederation, which guaranteed that every state remained sovereign, free, and independent. But specifically, the 10th Amendment, it keeps the reserved powers to the states, the things they didn't give. But the 10th Amendment also says that the police power remains with the states. Now, when we talk about police power, we're not talking about the guys that wear blue and have the blue flashing lights. Police power is the power of local governments to regulate for health, safety, welfare, and morals. So local government, local and state government has the police power. And if you look back in American history, the state and the local government is where your police come from. It's not a federal function. It was never intended to be a federal function. And even as late as, you know, the Depression era, when the FBI was really kicking up and becoming a force in crime fighting in the Depression era, when they were going after John Dillinger and Babyface Nelson and people like that. In the early days, FBI agents didn't even carry a gun because they needed local law enforcement to do the arresting for them. That's because the 10th Amendment really says the police power belongs to state and local government. That I think the founders would be very concerned about the size of the federal government today, and I think they would be very concerned probably about maybe even federal agencies, because to them, police authority was something that came from state and local government, and it was a way to continue to protect the people from a central government that was too powerful. And then finally, the last thing that the 10th Amendment does is it explains when it says here, the powers not delegated to the United States by the Constitution nor prohibited by it to the states are reserved to the states respectively or to the people. It means that some things the people kept and they didn't delegate to either federal or state, because the people ultimately are sovereign. The people make the decision. It's their call, not the government's. We created it. The government is a creation of the people of the states. So, just a quick overview of the first 10 amendments, the Bill of Rights. I'm not going to belabor the point. I've kept you too long already. But does anybody have any thoughts or comments maybe before I leave that you just occurred to you, maybe that you want to throw out or ask a question in particular about or bring up? Yes, sir?
For many years, of course, black people, the Native Indians, and other people, not considered citizens. Were they allowed to have any rights? I mean, constitutional rights?
It would certainly depend on, the state, what state laws said, because the founders would have simply said that the purpose of the Constitution was to keep the federal government off the people's backs. So the way that was exercised would have probably varied from state to state to some extent. There were decisions later, like the Dred Scott case of the United States Supreme Court, which said that people have the right, and of course the Constitution does recognize slaves as property, and that was recognized in the Constitution. So it depended on if somebody was free, if they were a slave, or if they were indentured servants, or that type of thing. So the answer would be yes or no. It would just vary, depending. Good question. Yeah, other questions? Yes, sir.
They're on about the 6th. Especially on the line about being confronted with the witnesses against
right.
drugs, and especially in the cases around abduction, kidnapping, human trafficking.
Right.
And I know some states are turning towards things like video testimony and stuff, but some states aren't.
Right.
Where does this play into that conversation?
What you're talking about there there is several United States Supreme Court case called confrontation cases, and it refers to the confrontation clause, which you're making reference to there, because a person has a right to confront their accusers, and that's constitutional. So they can demand to see who's accusing them, and you can see it's a great principle, because can you imagine being picked up and arrested and not knowing who's accusing you and what they're accusing you of, and that's why you have a right to be informed of the charges against you. And you also have the right of compulsory process. I'm glad you brought that up, because I meant to mention this. Compulsory process is just simply, most of these guys were lawyers, and they were using legal terms here to some extent. Not legalese, but really it's words that they would have understood. Compulsory process just means you have the right to demand the court subpoena people and order them to be brought in if there are witnesses in your favor. So you have the right to subpoena and demand people come in to testify if you think that they have information to give. And that is to protect your rights. The only time it does come into play is when you're talking about complicated cases, or maybe victims who are minors. And in that case, it depends on the jurisdiction probably, or whatever. I'm not overly familiar with all the Supreme Court cases touching on that issue, but if those themes have been hammered out, it could be developing federal case law, as to what is required and what's allowed, so as not to step on the confrontation clause, because everybody has a right to see who's accusing them.
Yeah. So in South Carolina, what would be just the standard approach to that?
The general rule is that the accuser's got to be present. The only way, and just like it also says here that you've got a right to a speedy and public trial. There are instances when a judge can close a courtroom. We can do that in like a preliminary hearing, but it's a rare case, because the media or anybody else has a right to come in and walk in and observe court proceedings anytime they want. Same thing with the confrontation clause. The rule is, they've got to be there to accuse you in person to testify. So it would have to be some special situation, something that would be the exception to the rule. I don't have jurisdiction as a Spartanburg magistrate over. My jurisdiction only begins when somebody's 17 or older. So I have 17-year-olds in court, but nobody younger than that. So it doesn't come up in my court. So it would probably depend on whatever circuit court rules are, or maybe federal court rules. Yes, sir.
Highest ranking law enforcement officer within a given county, is it not the sheriff?
I would say so, yes. Mm-hmm.
Even above federal law enforcement?
I would say so,
That's my first phone call. If I have a federal agent standing at my door, I'm calling the sheriff.
I would say so, yeah. The sheriff answers to the people of the county, and that's primarily it. The county's his jurisdiction. So yes, there's all kinds of situations, and throughout American history, the federal-state confrontations and that type of thing. But the founders would have been very nervous about judging from the history and what they say here, about a lot. They were nervous about federal strength or centralized power anyway. Their experience dictated it because they'd gone through the Revolution. So that is, I'd say probably so, yeah. That's his jurisdiction. By the way, interesting question. I mentioned just a minute ago about the FBI changed a lot because of the years that it was under J. Edgar Hoover. It was an investigating agency, initially, but one of the first. This is the $100 question, I guess. The first G-man that was the first FBI agent to really become world famous because he took down John Dillinger and Babyface Nelson, Pretty Boy Floyd. Y'all know who that was, right? Who was that? It's close. Elliot Ness, actually, he was a Treasury agent. Yeah, and he actually applied for to work for the FBI, but they say that Hoover never actually looked at his application. But he took down Al Capone, but he was as like a Treasury agent. So he went to enforce the Volstead Act, against the illegal liquor, bootlegging. But the first FBI agent, it was Melvin Purvis. Does that name ring a bell? Melvin Purvis,
Southern part of our state.
South Carolinian. Yeah, the guy who got John Dillinger was a South Carolinian.
Last year.
That's right. He has. He died, and of course he left the FBI not long after John Dillinger was shot, and of course he died in 1960. But he was South Carolinian. Just interesting little anecdote there. Any other thoughts or questions?
Why don't you close the time about
With the name? Yeah. I'll tell you this. My wife pointed out. She said, you got to be careful what you name people, because, as I said, my oldest son's name is his name's Sumter. My first name's William, so his first name's William too, and Sumter's his middle name, William Sumter Chumley, but he goes by Sumter. You got to watch out what you name people, because it seems like they sort of take on that personality. And General Sumter he's one of my favorite characters in history. He lived to be 98 years old. He was the last surviving general of the Revolution. And when he died in 1832, South Carolina was already embroiled in nullification controversy. And one of the last official public acts that Thomas Sumter did was issue a support of Calhoun in his doctrine of nullification. So, but Sumter, pretty well made his own rules. And one thing that Tarleton always said about him was, remember Tarleton gave the Swamp Fox his name because he chased him one day for 4 hours through the swamps and never even caught a glimpse of him. And finally the quote was, Tarleton said, allegedly he said, "Enough of this damned old fox. The devil himself couldn't catch him. Let's go pick a fight with a gamecock." And so that's what gave the Swamp Fox his name, was from Tarleton. And he knew that he could pick a fight with Sumter because Sumter would always come out and fight. Not that Marion wouldn't. He was just so slick, he would hide in the bushes until he was ready, and then he'd hit you when you didn't expect it. Sumter would come out and fight. And so I found that to be the case. We named our son Sumter, and now I've had to try and get him out of all kinds of fights all the time. That's okay. He loves liberty. So,
Your fault.
that's right. In fact, there he is calling now. So, sorry. Thank y'all for having me. We appreciate it. Thanks so much.
Thank you, Judge.